Hello students, this is Sunil Singh and you are watching a lecture on polity, a very important topic of polity, which is a small video but yet very important from the point of view of written exam not only, but it is also important for interview also, for different discussions, debates also, group discussions also. So the topic is preventive detention, which is called to be Nivarak Nirodh in Hindi. So we will discuss different aspects of this topic, what the preventive detention is exactly, what are its provisions, how does it affect the administration and the rule, and how it is important. So let us first take what the preventive detention is. You see, preventive detention is a kind of law. It is a category of law. A law which has provisions to arrest a person when the crime is not committed. You see, generally people are arrested when a crime is committed and somebody is suspected to commit that crime, and that is why he is arrested. But in the case of a preventive detention law, a person could be arrested even when the crime is not committed. अपराध हुआ ही नहीं है, crime अभी हुआ ही नहीं है, but even though somebody can be arrested, then such laws are called to be a preventive detention law. Preventive detention law in which the crime is not committed. So you can understand that these kind of laws are not meant to control the criminals, are not meant to punish somebody, are not meant to detain a criminal. Rather, the main objective of such laws is to check a crime to be happen, a crime to be committed. It is the main intention is to control the crime. When somebody is threatened to threatened to commit some kind of crime, then people can arrest even before the commitment of such crime. Then such law is called to be a preventive detention law. So preventive detention law is not itself a law. Rather, it is a category of laws. Several laws are there which comes under the category of preventive detention law. You may see there is a National Security Act, which is called to be in Hindi Rashtriya Suraksha Kanun, in which a person could be arrested even before he committed something, even before he committed some kind of crime. Rasuka. And there are other several laws like Makoka is there. Maharashtra Control of Organized Crimes Act. Let me repeat. Maharashtra Control of Organized Crimes Act. Makoka. This is also a kind of preventive detention law. You may consider different other kanun laws are there, like Guj Koka is there, UP Koka is there, and other laws like POTA, Prevention of Terrorism Act. Although it is abolished now, but it was a preventive detention law. POTA, TADA, Terrorism and Anti-Destructive Act. TADA. All these laws are considered to be preventive detention law in which a person could be arrested even before the crime is committed. So this is what the preventive detention is exactly. Now what are the provisions? But before consider the provisions, let me describe a part of fundamental rights. Actually, the preventive detention is mentioned in Indian Constitution in Article 22(4) and 22(7), which is actually a fundamental right. Article 22 is a fundamental right. From 19 to 22, they are given right to freedom, fundamental right to freedom in our Constitution. So Article 22 is right to liberty given to somebody who is being arrested. Liberty given, freedom given to somebody who is being arrested. And few fundamental rights are given to a person who is being arrested. First, he will be informed the grounds on which he is being arrested. उसको बताया जाएगा why he is being arrested. First. Secondly, he will be produced before a magistrate. He must be produced before a magistrate, before the nearest magistrate within 24 hours of his arrest. When he is arrested, he must be produced before a magistrate so that the magistrate can decide whether he is supposed to be kept arrested or not. Whether he is supposed to be kept arrested or not, that is going to be decided by the magistrate, and that is why he is needed to be produced before a magistrate within 24 hours. ये एक right उसको है. Third, he has right to have advice of an advocate of his own choice. He can choose an advocate from which he wants to take advice. So he has all this freedom. First, he must be he must know the grounds on which he is being arrested. Secondly, he must be produced before a magistrate within 24 hours. And third, he has right to take advice from an advocate of his own choice. But Article 22 also says that this power, these liberties, these freedoms are not going to be given to a person who is being arrested under preventive detention. Now, this is how preventive detention and fundamental rights are related. Listen carefully. These liberties which are given in Article 22 are not going to be given to a person who is being arrested under preventive detention law. प्रिवेंटिव डिटेंशन लॉ में यदि किसी को अरेस्ट किया गया है, he is not supposed to be given these liberties which are mentioned in Article 22. Then it means that if somebody is arrested under preventive detention, he is not supposed to be produced before a magistrate within 24 hours. He may be kept arrested even longer. He may be kept arrested for 2 days, 3 days, 5 days. Even he could be kept arrested up to 3 months. That is the limit. 3 months is the limit. After 3 months, he cannot be kept arrested. He may be kept arrested even after that, but only after a legal board's advice. So that is a different matter. But yes, there is a limit in preventive detention law also, that how long a person could be kept arrested under a preventive detention law. So all these liberties which are given in Article 22 are not going to be given to a person who is being arrested under preventive detention law. Why preventive detention law is made? Let us consider the importance. Importance is that, as I earlier said, that it is not meant to punish somebody. You see, it is not meant to detain somebody. It is only meant to detain somebody so that he cannot commit further crime. He cannot commit a crime. So this is how preventive detention is. If there be any question, you may ask. Thank you.